Donald Trump has long signaled that a key part of his defense against the many charges he now faces for trying to overturn the 2020 election is that he was not lying. He actually believed that he won the election. Trump's criminal defense attorney, John Lauro, said in an email to NBC News last month that, quote, Trump believed in his heart of hearts that he had won that election. And as any American citizen, he had a right to speak out under the First Amendment, end quote. But the burden of proof in this case falls on the prosecution to persuade the jury that Trump knew he was lying. And despite all the evidence, all the testimony from Trump's advisors and administration officials who told him that there was no evidence of electoral fraud, it still may be a tall order to persuade the jury that Trump knew he was lying, especially if Trump swears on his good faith to the court that he believes he won the election. But according to one law professor, none of this might be necessary. Burt Neuborne, professor emeritus at NYU Law School, writes in a new op-ed for the New York Times that Trump could potentially be prosecuted for what is known as willful blindness, the legal equivalent of proving guilty knowledge. Willful blindness goes back to a Supreme Court decision from a decade ago. The opinion, written by Justice Alito, reads, quote, many criminal statutes require proof that a defendant acted knowingly or willfully, and courts applying the doctrine of willful blindness hold that the defendant cannot escape the reach of these statutes by deliberately shielding themselves from clear evidence of critical facts that are strongly suggested by the circumstances. Defendants who behave in this manner are just as culpable as those who have actual knowledge. In other words, a person who knows enough to choose to ignore the evidence is just as responsible as the person who knows the facts. Take this line from Bill Barr's testimony to the committee. Quote, when I went into this and would, tell them how crazy some of these allegations were, there was never an indication of interest in what the actual facts were, end quote. This is really important. Over and over again, the truth was laid out in front of Trump by people who were in a position to know about whether the election was stolen or not. And it seems that over and over again, he chose to close his eyes to it. Trump's ignorance is not bliss. It's willful, and it may be his downfall. Joining me now is the professor emeritus and founding legal director of the Brennan Center for Justice at NYU Law School, Burt Neuborne. Professor, good to see you. Thank you for being with us. I want to read you something. It's paragraph 3 from the January 6th indictment. This is Jack Smith's indictment. Paragraph 3 of the entire indictment, it's on page 2. It reads, the defendant, meaning Donald Trump, had a right, like every American, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election and that he had won. He was also entitled to formally challenge the results of an election through lawful and appropriate means, such as by seeking recounts or audits of the popular vote, or filing lawsuits challenging ballots and procedures. Instead, in many cases, the defendant did pursue these methods of contesting the election. His efforts to change the outcome in any state through recounts, audits, or legal challenges were uniformly unsuccessful. So it's not just that he wasn't listening to Bill Barr. He wasn't listening to the recounts. He wasn't listening to the audits. He wasn't listening to the court cases. At some point, you can't claim willful ignorance.
Exactly. I mean, he wasn't listening to anyone except what he wanted to hear. And if the law was that people could get off, could essentially ignore their legal obligations by simply closing their eyes to any inconvenient facts that would cause them to have to do something that they didn't want to do, then we have an anarchic situation where everybody would pick and choose what kind of laws they would abide by. For hundreds of years in the English legal tradition and now recognized by the Supreme Court, there's been a rule that says that if you play ostrich and stick your head in the sand and just refuse to acknowledge that there are facts on the ground that force you to behave in a particular way, when you get hailed into court for that, you can't say, but I didn't know. You can't hold me responsible. I didn't know. The courts say that you were willfully blind. Now, the difficulty for somebody like Jack Smith is going to be able to have to prove to 12 randomly selected jurors that Trump was acting in a willfully blind way. And I think given the facts that you laid out, Ollie, that he just never allows anything to impinge in his consciousness if it gets in the way of what he wants to do, that this guy has made a lifetime of being willfully blind. That's his modus operandi.
So I guess my question then, Bert, is that his defense? That I never listen to anything, right? I get an idea in my head and that's what it is.
Well, ironically, if it weren't somebody like Trump, if I were representing an ordinary defendant and I was trying to get him off, I was his defense lawyer, and he was psychologically incapable of processing information that made his life harder, I would enter a kind of diminished responsibility defense. I would say this guy is psychologically so unable to deal with the potential for failure, that it's not fair to hold him responsible in a criminal court. And he would then be found guilty with diminished responsibility and be placed in some sort of mental institution. Now, of course, Trump is not going to raise that defense. He'll go to jail before he acknowledges that his mental capacity is such that he's incapable of hearing it when a woman says no. He's incapable of hearing things that get in his way. And he's not going to raise that defense. So even if it was the defense that might get an ordinary person some sort of a leniency in the law, he's going to go down with the ship, claiming that he knew and he was perfectly right and he won and he still believes he won. And it will be Smith's job, and it's not an easy job. It's not a slam dunk. It will be Smith's job to persuade all 12 people that he was being willfully blind beyond a reasonable doubt. I mean, remember, if one juror harbors a doubt about this, then the case will hang. The jury will hang. They won't be able to convict him. That doesn't get Trump off. He can then be tried a second time and even a third time. The only thing that gets him off forever would be a unanimous acquittal. And that's not going to happen. So the best he can hope for is a hung jury and a second trial.
This is good information for us as we watch this case and the case in Georgia proceed. Bert, thanks very much for your perspective on this. Bert Neuborne is the founding legal director of the Brennan Center for Justice at NYU Law School.